convicted under section 366, 363
Under?
for 4 years and 366A, 363A for 6 years and 12 year in PASCO Act section 4, my lord. The prosecution case, my lord, the mother of the victim is the informant, my lord. She has stated that the petition applicant and mother, father and brother and other person has kidnapped his daughter, my lord. During the course of trial, my lord, 7 witnesses has been examined, my lord. 1 and 2 has stated in his evidence that they saw the victim girl with the applicant at the Ghoga station, my lord. The PW 3 and 4 has not stated they have seen with the applicant, my lord. The PW 5, the
Just a minute. Victim was examined.
my lord, PW 5.
What is your age?
Age, my lord, in medical examination, my lord.
What is your age?
My lord, my 36. He is the major, my lord. Age 24, 25 years. 26 years.
So how do you meet with the evidence of PW5 that is against you?
My lord,
How do you meet evidence of PW5?
PW 5. The
Yes.
victim, my lord.
Yes.
My
So she has made categorical statement against you. Her deposition is direct against you.
my lord, but my lord, according to evidence, my lord, the applicant called and thereafter she went there, my lord.
Then
My lord,
she is
but
a minor.
But medical examination, my nothing has come, my
Maybe.
lord. My lord. My lord, 164 examination, my lord, she has stated she has gone in train, my lord. But in evidence, my lord, she has stated he has gone in car, my lord. Contradictory statement in 164 statement and the evidence, my lord, of the
Maybe.
victim, my lord. My lord, Exhibit D, my lord, Exhibit D, my lord, discuss in my lord judgment, my lord.
What is Exhibit D?
Exhibit D is a letter written by the victim to the SP Bhagalpur. She has not kidnapped by anyone. She has kept in other places, and the false case has been filed.
So that aspect has been dealt with in her deposition.
My lord,
That she was compelled to write that letter.
my lord, the letter has been exhibited, my lord.
Mr. Counsel, in her evidence at the trial, she specifically deposed that she was compelled to write a letter to the Superintendent of Police. This is her evidence.
My the IO, my lord, has not visited the place of occurrence, my lord. Even he has not come to Patna. Whether the victim has been kept in Patna, my lord. Nothing, my lord, has come on record, my lord, during the course of investigation, my lord. The applicant is remain in jail, my lord, more than 5 months, 5 years, my lord.
Not now. IA number 1 of 2021, 1 of 2021, the appellant has filed this application for his release on bail and suspension of sentence under section 389(1) of the CRPC during the pendency of this appeal. Stop. Next, by the judgment and order under appeal dated 16/9/2019 of the 26/9/2019, the appellant has been convicted of the offences punishable under sections 366A and 363 of the Indian Penal Code, as well as section 4 of the Protection of Children from Sexual Offences Act 2012. Full stop. For the offence punishable under section 4 of the POCSO Act, the appellant has been sentenced to undergo imprisonment for 12 years with fine. Full stop. He has also been sentenced to undergo imprisonment for 5 years for the offence punishable under section 366A and 363 of the Indian Penal Code. Stop. Next, learned counsel appearing on behalf of the appellant has submitted that the medical evidence does not support the prosecution's case, and therefore the prosecution story is false. Stop. He has further submitted that there is contradiction between the statement of the victim recorded under section 164 of the CRPC and that made before the court below during the course of the trial, which makes the prosecution's case doubtful. So stop. Next, we have perused the impugned judgment of the trial court and other materials available on record. So stop. The victim has been held to be a minor who in her deposition has specifically stated the petitioner's appellant's misdeeds. Full stop. The medical examination was done 5 days after the date of occurrence. So stop. Next, there being direct evidence against the appellant's role, showing appellant's role, comma, we are not inclined to grant him to exercise our discretion under section 389 bracketed 1 the
Applicant
CRPC
remain
for
in
the
minor more than 5 years.
present. Stop. The appellant shall, however, be at liberty to renew his prayer for bail after he completes half of the sentence and half of the maximum sentence, and if in the meanwhile the appeal is not taken up for final hearing. Yes.
26 Criminal Appeal DB. 137